Welcome to Civil Procedure Video 7, Personal Jurisdiction. This is video 7 of the public series on the personal jurisdiction module. This video, we will cover Asahi Metal Industry Company versus the Superior Court of California. The year of this opinion is 1987. Before we jump into Asahi, let's do a quick review of the evolution that we have walked through thus far. In Penori v. Neff, that's where the Supreme Court constitutionalizes personal jurisdiction. From there, in 1945, we go to International Shoe. And in International Shoe, although we are introduced to different doctrine, like the specific jurisdiction doctrine and the general jurisdiction doctrine, which are not actually called those names in International Shoe. But that's where we get the first sighting. We learn about the nature and quality of contracts. We learn about continuous and systematic when it comes to minimum contacts. We get a lot out of International Shoe, but the two things that really need to imprint upon you are the minimum contacts, step one, and the traditional notions of fair play and substantial justice, which is step two. Yeah. After that, we go to Hansen v. Dinkla. That's in 1958. And what we get out of Hansen v. Dinkla is language that makes it very clear that when we are looking at minimum contacts, those contacts must be contacts that the defendant made intentionally with the form state. We call that purposeful availment. So when we talk about purposeful availment, we are still speaking of minimum contacts, but we are speaking about the type. We are speaking about the kind of contacts. Those are contacts that have been made by the defendant with an intention of the defendant to develop this relationship with the form state. After Hansen v. Dinkla in 1958, we go to Worldwide Volkswagen in 1980, and Worldwide Volkswagen reaffirms purposeful availment. So it's a affirmation, a confirmation, a reaffirmation of minimum contacts must be purposefully intended by the defendant, right? Purposefully intended by the defendant. In 1985, we get to Burger King. And in Burger King, we get to see the Supreme Court utilize both prong one, minimum contacts, and prong two, fairness factors. Those fairness factors are the factors that are considered in order for us to determine whether or not exercising jurisdiction by the forum court over that non-resident defendant, whether or not the exercise of that personal jurisdiction is going to violate traditional notions of fair play and substantial justice. We have 5 fairness factors that must be considered. And it's in Burger King, out of the litany of our cases, that we actually get to see for the very first time the Supreme Court actually follow through with both of those analysis, because in Burger King, we finally satisfy the purposeful availment of the minimum contacts. So with Burger King, we get a clarification of what specific jurisdiction is and what it requires. And then once we get that, right, because that's going to reaffirm the purposeful availment. And once we've established that, we get to see the Supreme Court name and go through the fairness factors. After Burger King in 1985, we take a step back. We take a step back to look at helicoptores because before we get too far along, as we have developed the doctrine of specific jurisdiction, we want to also develop the doctrine of general jurisdiction. And that's what we get from helicopteros. Now, we don't get to the fairness factors in helicopteros because we don't establish minimum contacts. Right? See the rhythm? It's a nice rhythm. It's a nice rhythm. And now, 1987, we get back to Asahi. So that is the case that we are going to cover. In helicopteros, the Supreme Court confirmed that general jurisdiction requires truly continuous and systematic contacts. Truly continuous and systematic contacts. Mere purchases or occasional trips into the form state by the non-resident defendant is not enough to establish that the defendant is at home. We have a parting of the sea. If we are looking at a case that has specific jurisdiction, the standard to determine whether or not personal jurisdiction can be exercised by the forum court, right, is going to be minimum contact, step one, and a consideration of the fairness factors of step two, so that we can make a determination if exercising that personal jurisdiction because they're minimum contacts, if that's going to violate traditional notions of fair play and substantial justice, right? So that's what helicopteros gave us. It gave us the second path, right? Because if it's general jurisdiction, we are not looking at minimum contacts. We are not looking at those fairness factors. What are we looking at? If it's general jurisdiction, the test that has to be applied to determine whether or not it would be constitutional for the forum state to exercise personal jurisdiction over that non-resident defendant is whether or not that non-resident defendant is at home in the foreign state. Not every corporate relationship with a foreign state is going to justify general jurisdiction. That was the beauty of helicopteros. Okay, let's look at Asahi, 1987. What does Asahi give us? Well, if we take a moment and just think back just briefly, with helicopteros narrowing the reach of general jurisdiction, right, making it clear that every activity is not going to be enough to justify jurisdiction, we are left with a question. And that question is, what happens when the lawsuit arises from products that are predictably placed in a forum state through a nationwide or worldwide distribution system? What am I talking about? I'm talking about stream of commerce. If we have a product that is placed into the stream of commerce with the knowledge, with the knowledge that this product, through this nationwide or worldwide distribution system, is going to reach this forum state, is that general? Or, no, right? Is that specific? Hmm, hmm, hmm. And hopefully, you've decided immediately that you know for certain which one it is. Think, think. Clearly, it's specific jurisdiction, right? Okay. So, in the context of personal jurisdiction, this is what stream of commerce means. Stream of commerce is really a legal metaphor. It's a metaphor that's used by courts to describe the regular, predictable flow of goods through a chain of distribution. Through a chain of distribution. So we are looking at something that is regular. We are looking at something that is predictable. We are looking at something that goes through a system. Yeah. And this stream of commerce theory is important because when a company places its product in that stream of commerce, knowing that the product will be sold nationwide or worldwide, hasn't it purposefully availed itself of every state where that product may end up? Hasn't it? It has, hasn't it? This is the question that is the heart of specific jurisdiction. So the stream of commerce debate matters because it defines the outer limits of when a court can hail an out of state or foreign defendant into a forum state based on the movement of those goods. That's why it matters. It's especially important in an era of global distribution chains where a single component manufactured abroad may find its way into thousands of different products sold all across the United States. This is a really big deal. The debate is going to be if a manufacturer places the goods in the system, is it purposeful availment? Here's a preview of the outcome. O'Connor, Honorable Justice O'Connor, who opined the opinion or who wrote the opinion for the court, says no. No. Knowing that the product is going through this distribution system and knowing that the purpose of that distribution system is to spread this product far and wide is not enough to satisfy purposeful availment. That's what Justice O'Connor and the three justices that voted with her says. Justice Brennan said, yeah, it's enough. If you are aware that your goods are predictably, regularly, through a system, is going to reach a form, well, then that's purposeful availment. That's enough. And the three justices that voted with Brennan are saying yes. Justice Stevens had a whole nother idea about it. So before we go any further, let's stop and make a distinction between Worldwide Volkswagen and Asahi. Asahi is saying you are intentionally placing your product in a national or worldwide system of distribution. And that system of distribution is such so that it distributes. You know your product is going to wind up far and wide and lots of places. It's your purpose, it's your intent for your product to find itself far and wide in lots of places and lots of spaces, right? That's very different than worldwide Volkswagen, where the New York retailer and the New York distributor had no intent that their vehicle was going to be placed in a system of distribution where that car could wind up all over the United States. The retailer and the distributor were not worldwide, were not nationwide, they were local. And they sold the vehicle to a private family with no intent of that vehicle finding its way through a stream of commerce. See the difference? Asahi, there's some intent to be spread far and wide. In worldwide Volkswagen, there was no intent to be spread far and wide. So let's get back to the facts. The facts of Asahi. What's going on? We have a California motorist who was injured when he was riding his motorcycle on a California highway and his tire blew out. Now, it's alleged that the reason that the tire blew was because the tube and the valve, actually specifically the valve, was defective, right? And so the injured motorist, we call him the plaintiff, sued Cheng Shin Rubber Industrial Company. Who is that? Well, that's the defendant, but that is a Taiwanese tire manufacturer, right? A Taiwanese tire manufacturer. So we have a plaintiff injured in California, brings a lawsuit in California state court against a non-resident defendant, Cheng Shin, because of the allegation of a defective valve in a tire that blew up. So the motorcycle rider didn't sue the valve manufacturer that's allegedly defective. He sued the tire company that the valve was a product of. Got it? Now, so how do we get to Asahi? Asahi is the Japanese valve manufacturer. Got it? So the valve was manufactured by Asahi in Japan. The valve went into a tire that was manufactured in Taiwan. That got to the motorcycle on the plaintiff's motorcycle and it blew and caused the plaintiff injuries. The plaintiff could have sued both Cheng Shin and Asahi. He didn't. He chose to sue Cheng Shin. Yeah. Cheng Shin chose to sue via a third party complaint Asahi. That's how we get Asahi, right? So Cheng Shin said, well, hold on a second. If the motorcycle guy is going to sue me because the tire blew, and if I find to be liable to the motorcycle guy, then Asahi, who made the defective valve, should indemnify me, which means Asahi's got to be a part of this lawsuit. And since the plaintiff didn't sue Asahi, Cheng Shin decided to sue Asahi, the impleader. That's going to be Federal Rule Civil Procedure 14. And that is one of the rules that you're going to need to know, right? Federal Rule Civil Procedure 14, impleter. All right. So we've got the three parties and we understand how they got there. Yeah. We've got the three parties and we understand how they got there. What is the chain of distribution? The tire manufactured by Changshin in Taiwan. The valve assembly is manufactured by Asahi in Japan. Asahi sold the valves to Changshin, knowing that the valves would be incorporated into tires for worldwide distribution. See it? This is it. Did Asahi, by placing their product in the stream of commerce, knowing that that distribution from that stream of commerce was going to send their components far and wide, one of those places was California. Did Asahi thereby purposefully avail themselves to the rule of law in California? Now, you think it's interesting. It's a little more interesting. I know you know. You read it. By the time this case actually makes its way through the state court system and makes its way before the United States Supreme Court, the original plaintiff, that's the motorcycle rider, had settled his lawsuit with Changshin. So what does that mean? Well, it means he settled his lawsuit. So the original plaintiff has now dropped out of the lawsuit. So the only live parties are going to be between the third party plaintiff, that's Cheng Shin, and the third party defendant, that's Asahi. Why didn't their lawsuit end when the motorcycles lawsuit ended? Because with that third party complaint, that is an independent suit that stands on its own. So even though the underlying claim has been resolved, the interpleader, that third party claim, becomes an independent claim on its own. However, what you can see though, right, what you can see is once we get to those fairness factors, one of those factors has just been completely undone. And that's going to be the interest of the forum in the litigation. California was interested in the litigation because California was the resident of the motorcycle person, right? So, of course, California has an interest to make sure that its people, its residents, are protected. Well, the California resident is out. And so the interest in California trying to keep that lawsuit just became pretty close to zero, right? Just became pretty close to zero. Going back to some facts that we didn't point out is Asahi, who's now the third party defendant, right, has no offices in California, has no property in California, has no bank accounts in California, has no employees in California, didn't do any advertising in California. This sounds so familiar. This sounds so familiar. Isn't that how International Shoe started? Right. The only connection that Asahi has with California is its foreknowledge that its products are going to be placed in the stream of commerce. And one of the many places and spaces that that product is going to land is going to be California. When the motorcycle rider was still part of the case, California asserted specific jurisdiction. Why? Because it was the Asahi's valve, right, that ended up in the tire through the distribution system in the stream of commerce. What am I saying? What am I saying? I'm saying the lawsuit arose out of the activities that the defendants had with California. Yeah. Okay. Very good. We've talked about Federal Rule of Civil Procedure 14, which is the impleader. Now that we've framed the facts, let's look at the issue. This is the 3-point issue statement guide, right? I ask you for my issue statements, because I follow the format of the NCDE, I ask you for 3 points. I ask you for the governing rule of law. I ask you to reduce all of the chaos and the noise to a simple legal question that can be answered. And I ask you for a key fact that makes all the difference. If this fact did not exist, we would have to have a different legal question. I ask that your issue statements have 3 points: 1, 2, and 3. Here's an issue statement that meets that 3-point rule. Under the Due Process Clause of the 14th Amendment, that's the rule of law, is a foreign defendant's act of placing a product component into the stream of commerce. Get it? That's a formalized distribution system, right? With knowledge that it may reach the forum state. That's the key fact. By itself, is that sufficient to establish purposeful availment needed for minimum contacts? Or is additional conduct, like expressly targeting the forum, required? That's the legal question. Rule of law, key fact, legal question. Yes, the components are not necessarily in this order, because the sentence has to be correct in its syntax, and it has to be correct in its grammar. So sometimes maybe the key fact is even first and the rule of law is second. What I'm asking you for, I never said it had to be in that order. I said it needed to contain those 3 components. So there's an issue statement. Not the only issue statement. I'm sure that you can come up with lots that are probably better than that. But this one, it's not bad. What are we going to do? Because we've got the question. Is knowledge of your parts being distributed through a chain that's intended to distribute it, right? You know that you are putting your product in the stream for the point, for the purpose of this wide distribution, is knowing that enough to satisfy purposeful availment, so that I can show minimum contacts is satisfied. I can now go to the fairness factors of traditional notions of fair play and substantial justice. Or do I need the knowledge of that stream of commerce plus something else? Well, I've already previewed this for you and told you that the Supreme Court essentially broke. They splintered on that issue. The Supreme Court could not reach a majority. They were able to reach a plurality, but they couldn't reach a majority on the issue of minimum contacts. And if you can't reach a majority and you only have a plurality opinion, because that plurality opinion no longer has the authority of being binding. That's a big deal. That's a big deal. What do we have? We have for, in favor of, you need the knowledge plus something else. We have for that says the knowledge of being placed in the stream of commerce is enough. I got a tie, 4 and 4. And then I've got one that's not in it, right? I got one that's got a completely different thought process about how this is supposed to go. I have a tie. Why is it a plurality? Well, it's a plurality in favor of O'Connor because she was chosen by the Chief Justice to write the opinion. And so her vote is going to be the plurality, not the concurring. Okay, so where does that leave us? We have three competing frameworks for analyzing the minimum contact piece. So what do we do? Well, let's just play out the minimum contact piece, right? Let's just play out the minimum contact piece so that we can actually see what's going on. Justice O'Connor, in the plurality opinion, said stream of commerce plus. She and the three justices that voted with her said that stream of commerce alone is not enough. You got to have something extra. Whether that extra is advertising in the form, whether that extra is designing products specifically for that form, that's right, targeting that market, whether that extra is establishing customer service channels in that form, whether that extra is having distributors or agents or somebody in the form, whatever the extra is, these are just examples of what the extra can be. But whatever the extra is, there must be something in addition to the stream of commerce. Justice Brennan said the stream of commerce is enough. Stream of commerce is enough. If a company puts a product into a distribution chain and the company knows that they are being marketed or sold everywhere, potentially even in this form, then that awareness alone is purposeful availment, according to Brennan and the three justices that agreed with him. Justice Stevens says, let's be more practical. Justice Stevens sounds like the holdout pragmatist, right? Sounds like the holdout pragmatist. Justice Stevens says, let's look at fairness and balance. Let's look at the volume of the products, right, that are entering the form as a result of the stream of commerce. Let's look at the value of those products. Let's look at the hazardness of those products, if there's any hazard. Now, if Stevens was forced to guess, Stevens says, just based upon the sheer number of valves that are entering California through this formal stream of commerce distribution system, just by the number alone, it's probably enough. But he didn't have to make a choice, and he didn't make a choice. So we're stuck. We're stuck, right? So we're stuck. What do we do? What we don't do is leave. And I giggle, right? What we don't do is leave. And I giggle because that seems to be the opposite of what Burger King said. And Burger King said, when you are conducting your constitutional analysis, you follow a two-step sequence. You have to address the minimum contacts first, right? If you don't have minimum contacts, you stop. Game over. You never get to the fairness factors. And Burger King was very clear. If you do have minimum contacts, then you proceed to step 2. And step 2 is evaluating whether or not exercising jurisdiction, personal, would violate fair play and substantial justice. Got it? Burger King was very clear. Constitutional analysis, 2 steps, minimum contacts. If you don't have it, done. Minimum contacts, if you do have it, proceed to step 2, which is where you're going to evaluate your fairness factors. Well, do we have an answer in Asahi? We've got a 4-4 split. So does that mean that we stop? No, we don't stop. Why not? Because we don't have a majority decision one way or the other when it comes to the contacts. We do not have a majority decision one way or the other when it comes to the contacts. We've got 4 that says it's enough, and we've got 4 that says it's not enough. So, what do you do when there's a tie? When there's a tie, you have to go to the fairness factors. When there's a tie, you're going to have to go to the fairness factors. So, that's what you do. Here's your fairness factors. When we look at the fairness factors, well, no, I'm sorry. These are the minimum contact factors. Let's look at the fairness factors. There we go. The fairness factors are green. Burden on the defendant. That's fairness factor number 1. What is the burden on the defendant? Who's the defendant? That's Asahi, because the tire manufacturer has become the third-party plaintiff. So the third-party defendant is Asahi. Well, this is a unique situation because both the third-party defendant and the third-party plaintiff are foreign companies. Well, that's going to be extremely burdenful for both of them if they have to try this suit in California. Remember, California's reason for being there was because of the plaintiff, and the plaintiff has settled his lawsuit. And so, what is the burden on the defendant if they had to come to California? Well, on the plaintiff and the defendant in this situation, it's huge. So, that's going to weigh against California exercising jurisdiction, right? Number 2, what is the forum state's interest? Well, we already previewed that, right? California was 100% interested when the motorcyclist was involved because the motorcyclist was a resident of California. But now that the motorcyclist is no longer involved, California is not interested in this lawsuit, right? So that's going to weigh against exercising jurisdiction because what are you going to do? You're going to wind up tying up California courts for a case where California really didn't have any interest. Well, that's not judicially economical, right? Okay, so what's the third burden? The third burden is the plaintiff's interest. Well, what's the plaintiff's interest? Again, the third party plaintiff is a foreign company as well, which means that they would have to come from Taiwan and set up shop to pursue their indemnity claim against the Japanese company Asahi. That's not convenient. That's against jurisdiction. Well, let's look at factor number 4. Interstate international efficiency. Interstate international efficiency. Remember, I explained that's efficiency of the judicial system. Think about judicial efficiency. How is it judicially efficient for California to use its resources. That's its courtroom, its court reporters, its deputies, its bailiffs, its parking, its judges. Uh, how efficient is that to resolve a dispute between two foreign corporations with no U.S. plaintiff involved? Well, that's against jurisdiction. And let's look at shared interest, right? What are the shared interests? The idea that U.S. courts should be mindful of foreign nations' interest in disputes involving their corporations is important, but not when there is no U.S. involvement, right? While international comedy strongly favors being the good neighbor, being the good hostess, being the good neutral ground, the more you think about it, the more it's going to weigh against California exercising jurisdiction. Because if a California judge enters an order against one of those foreign territories, and the judge is going to have to rule one way or the other, does that benefit, not only does it benefit California, is that going to benefit the United States? Not at all. And so, even in the best of days, if the court was able to reach a majority in Asahi on minimum contacts, and even in the best of scenarios, if the court was able to find that minimum contacts existed, remember they didn't, but even if they did, the fairness factors are going to clearly stand against the exercise of personal jurisdiction. And so, in this unique case, the outcome would have been the same, which is to deny authorization to exercise personal jurisdiction, deny the exercise of personal jurisdiction. So, overall outcome, every single fairness factor pointed away from California. And that was something that all 9 justices could agree on. They were unanimous on the decision that jurisdiction in California would violate traditional notions of fair play and substantial justice. So that was the unanimous holding, right? The unanimous holding was on the fairness factors. So, in closing, what does our specific jurisdiction rule statement look like now? Looks like this. To satisfy due process, the exercise of specific jurisdiction requires 2 things. 1, that the defendant have minimum contacts with the forum state such that it has purposefully availed itself, right? So still minimum contacts. We just now have that clarifying purposefully availed itself. And number 2, jurisdiction be consistent with fair play and substantial justice, and that's evaluated under the 5 fairness factors, right? If I have minimum contacts, I go to the 5 fairness factors. If I don't have minimum contacts, I'll stop, provided that I have a majority that stands against the minimum contacts. If I wind up with another plurality, then I'm going to have to go to the justice factors, in essence, which this is a poor analogy, in essence, to break the tie. Got it? And that is Asahi. Yay! Fantastic. Looking forward to seeing you guys in class. If you have any questions, come prepared to ask them, and I'll do my best to be prepared to answer them. Thank you.